including journalists. The deputies have 4 minutes in total.
Thanks, Ken.
Deputy Clare Daly.
Thanks, Ken Corla. And I have to say we are very glad that the issue of surveillance and intrusion into the lives of citizens is finally being addressed, and a topic of conversation, because it's something that we've consistently tried to raise in here to complete disinterest from the media and the political establishment. And I have to say there's a certain double standards in the outcry over the GSOC access of accessing information of journalists' phone records, because the response to that has been entirely disproportionate vis-a-vis, for example, the fact that citizens have had their phone conversations from prisons with their solicitors tapped into and intercepted, that Gardaí have been involved in such activity also largely unmonitored. And I think it's important to say that the information that GSOC were seeking was part of a criminal investigation in relation to alleged Garda criminal activity. And we know that it has been a huge problem about Gardaí giving information to the press, information that's not often in the public interest, but actually is breaching the privacy of private citizens. It's very, very common, and no action or accountability is taken when that happens. So from that point of view, the Gardaí have to be accountable to somebody, and in this instance GSOC is the body responsible, and their powers that are now the subject of the public spotlight are powers which the Gardaí and other organisations also have. So I think it's really important that we seize the opportunity of this information coming into the public domain now, and somehow striking a chord now when it didn't last year or all the other years, to really look at this whole area, because rights of privacy and fundamental human rights are important. The Minister has said she's going to have a review, but it seems that you're only reviewing the 2011 Act with regard to information involving journalists. I think we need a review of the 2009 Surveillance Act, the 1993 Interception of Postable Packages and Telecommunications Messages Act, and that has to be done in the interests of all citizens, not just journalists, because citizens' rights have been abused by this lack of surveillance, and I didn't see too many journalists being concerned about that up to now.
Thank you, Deputy. And I'll call Deputy Mick Wallace.
Thank you, Cahill. Minister, in December 14, you stated that there was no question of any form of mass surveillance being carried out in Ireland. You went on to say that the implications of the reports was that it is happening within the UK's jurisdiction. When I raised the matter in here. However, it is very clear that every country makes its own legal arrangements for lawful interception, you said. I would expect that any such measures, if they were ever in operation, would have a proper legal basis, and that the level of interference would be proportionate to the aims sought to be achieved in any given country's legal approach. Then, in February 15, Minister, the UK's Investigatory Powers Tribunal ruled that the large-scale interceptions and collection of the public's personal communications data by GCHQ and the NSA was illegal, and was illegal prior to Snowden's disclosure of the vast GCHQ and NSA mass surveillance programme. The two spying programmes under investigation were PRISM and Upstream. Upstream accessed data in bulk from fibre optic communication cables, including all the major undersea cables carrying almost all communications between ordinary citizens in Ireland. I asked you multiple questions about this issue in January and June 15, and you repeatedly gave the same answer, suggesting that these were just media reports, that nothing unlawful was going on, and that Minister Flanagan had assurances from the UK that nothing was going on, and that even after GCHQ's oversight body had found them in breach of the law. Minister, I too think that before GSOC can look at anyone's phone, they should have to go before a court. But I also believe, and we've argued in this chamber before with you and with Minister Shatter before you, that so too should the guards. This idea that a guard can actually go to a superintendent or higher and get permission to interfere with someone's communications facilities is just madness. It just doesn't work. The people of Ireland don't want it to happen. The journalists don't want it to happen, but neither do the citizens. We don't want their phones tapped. And we don't want giving anybody, including the guards, the power to do that without having to go before a court and get it. If there's criminal activity, then get the permit through the courts. But this idea of a yearly review at the end of the year and the rubber stamping of everything that went on is nonsense for everybody, for GSOC and for the guards.
Thank you, Daly. Antara, Mrs. Gerald.
Thank you. I'm sure that all in this House will share my view that a free press plays an essential role in a democratic society in fostering full, free and informed debate on all issues of public concern. It is therefore, of course, of fundamental importance that journalists should be able to carry out their legitimate work unhindered. Concerns have been expressed over recent days about the question of access to the telephone records of journalists in the context of criminal investigations being carried out by GSOC. Access to communication data is governed by the Communications Data Retention Act of 2011. And I must emphasise that I do not have any role, and neither does my department, in the process of requesting or authorising access to telephone records under the 2011 Act. Telephone logs, that is, telephone records. Nor do I receive information, in fact, in relation to specific requests that are made in the course of those investigations. Of course, we've had many calls here for strong, independent monitoring in various arenas, and that's what we set up with GSOC. So it would not be appropriate in the context of the independent functions of bodies such as GSOC for me to have that kind of information, because they are an independent body and act independently. However, I would say, and as the House would be aware, genuine concerns, general issues of genuine concern have been raised about the balance in our current law between the important freedom that journalists should rightly have to pursue legitimate matters of public interest and the basic rights of persons not to have their personal information improperly disclosed. And of course, this raises very complex issues. We're talking here about the various balances between, for example, criminal investigation, the public interests, protecting sources, the rights of victims. And these are fundamental issues for any society and any democracy to manage in the best possible way. So I went to government today, and the government agreed to my proposal to establish an independent review of the law in respect of access to the phone records of journalists. I do want to make the point that this review will cover all bodies that can have access to records under the Data Retention Act, including GSOC and Garda Síochána, Defence Forces, the Revenue. If you look at the 2011 Act, which was introduced by the former Minister Dermot Ahern here in 2011, you will see that all of these bodies have this authority. I want to say to the House that I am very pleased that the distinguished former Chief Justice, Mr. Justice John Murray, who was also a former member of the European Court of Justice, has agreed to carry out the review. And I do want to express my appreciation for his immediate agreement to do this review. And I would expect and anticipate that the review will be completed in 3 months. So this is about looking at this issue and getting a speedy report into our legislation. And obviously he will be examining whether further safeguards, whether he believes they're necessary. And I've also asked him to look at the international situation. So the draft terms of reference of the review are to examine the legislative framework in respect of access by statutory bodies to communication data of journalists held by communication service providers, taking into account the principle of protection of journalistic sources, the need for statutory bodies with investigative and or prosecution powers to have access to data in order to prevent and detect serious crime. Because, of course, the criteria for accessing these logs and records, there has to be a clear criteria there, and is there, in relation to the offence, has to be a serious offence and punishable by up to 5 years. So the need for statutory bodies with investigative and or prosecution powers to have access to data in order to prevent and detect serious crime, and as I say, current best international practice in this area. With regard to GSOC in particular, while fully respecting the independence of the Ombudsman Commission, I was glad to meet this morning with the GSOC chairperson, Miss Justice Ellen Ring, who was appointed by this government some months ago, who is a judge of the High Court. She has assured me, and I do want to say this to the House, she has assured me of the clear and strict procedures that are in place in GSOC in respect of this area, operating fully within the law. Indeed, she emphasised to me that GSOC requests for access to telephone records are decided at the level of the chairperson. And as the deputies have said within An Garda Síochána, it is a request from superintendent and decided at chief superintendent level. I assured Ms Justice Ring, and I want to emphasise this to the House, that there is no question whatsoever of the review of the law in this area, reflecting any lack of confidence in GSOC. The review arises not from the facts of any particular case, but from the genuine concerns raised about the overall balance of the law in this area. While I am sure deputies share my view that statutory bodies investigating offences need to have the appropriate statutory powers available to them to carry out their duties, which are very important, we do need to examine the balance in respect of entirely legitimate journalistic activity being carried out in the public interest. And that's what I envisage the review doing.
Thank you, Minister. Deputy Clare Daly.
Thanks, Ceann Corlin. Minister, I have to say your response is completely inadequate and off the mark. The review of the 2011 Act in relation to journalists is not enough. All citizens deserve to have their privacy and human rights protected, and the rightful outcry in relation to journalists' phones being intercepted should be shared in relation to other citizens' rights. The 2009 Surveillance Act allows the Gardaí to break into somebody's house, to plant devices, to carry out secret recordings, to put a tracking device on their car, and some of these activities can be done on the say-so of a superior officer without any oversight or scrutiny or any definitive figures being produced later on. This is not good enough. Privacy and human rights are deserved by all, and I am appealing to you to look at the situation regarding all of the surveillance legislation which is on our books, the use of that and the powers that rest with the Gardaí, with the Revenue, with the Defence Forces and other state bodies which are not open to proper scrutiny or freedom of information requests. It's not just a matter for GSOC, and I think if you were really serious about freedom of the press and citizens' human rights, then those aspects would be being examined as well.